The Guidelines 06/2022 on the practical implementation of amicable settlements, adopted by the European Data Protection Board, EDPB, on 12 May 2022, provide comprehensive insights into handling amicable settlements under the GDPR framework. The document addresses various facets of amicable settlements, detailing their scope, legal basis, and practical implications for supervisory authorities, SAs, data controllers, and data subjects across the European Economic Area, EEA. This article synthesizes the key points from the guidelines, offering a cohesive narrative on the subject. Introduction to amicable settlements. Amicable settlements represent a pragmatic approach towards resolving disputes between data subjects and controllers, facilitated by supervisory authorities, SAs, under the GDPR framework. Despite the term amicable settlement not being explicitly defined within the GDPR, it broadly refers to alternative dispute resolutions that achieve a harmonious closure of cases, reflecting a consensus between the involved parties. The concept embraces various dispute resolution techniques, such as mediation and negotiation, aimed at resolving conflicts in a manner that is both friendly and devoid of discord. Legal foundation and practical implementation. The GDPR, through Recital 131, hints at the use of amicable settlements, particularly in handling local cases under Article 56(2), but does not confine its application strictly to such instances. This has led to varied interpretations and implementations across member states, influenced by national laws and the discretion of individual SAs. The guidelines emphasize that any amicable settlement process should align with the principles of good administration, ensuring fairness, transparency, and the right to be heard for all parties involved. Scope and aim of amicable settlements. The primary aim of amicable settlements under the GDPR is to expedite the resolution of disputes, fostering compliance with data protection laws and safeguarding data subjects' rights. The guidelines delineate the application of amicable settlements across different contexts, including local, cross-border, and cases that fall under the one-stop shop (OSS) mechanism. Notably, amicable settlements are advocated for cases originating from complaints by data subjects, where a direct dispute exists between them and a data controller. General legal analysis and recommendations. A significant portion of the guidelines is dedicated to offering a legal analysis of amicable settlements within the GDPR's framework. It clarifies the powers vested in SAs to pursue such settlements, the procedural intricacies in the OSS context, and the subsequent legal consequences. Practical recommendations for implementing amicable settlements are also provided, emphasizing the importance of cooperation among SAs, adherence to the principle of good administration, and ensuring the rights of data subjects are adequately protected. Challenges and limitations. The guidelines acknowledge the divergent approaches towards amicable settlements across the EEA, attributed to differing national legislations and procedural laws. A notable limitation is the exclusion of amicable settlements in certain member states due to national laws, underscoring the necessity for a harmonized approach to facilitate broader applicability and effectiveness of amicable settlements across the EU. Conclusion. The EDPB's guidelines on the practical implementation of amicable settlements under the GDPR mark a significant step towards harmonizing the approach to dispute resolution within the data protection landscape of the EU. By elucidating the legal basis, scope, and practical considerations for amicable settlements, the guidelines aim to encourage a uniform, fair, and effective resolution mechanism that upholds the principles of the GDPR, while taking into account the varied legal contexts of member states. The adoption of these guidelines signifies a move towards enhancing compliance, ensuring data subjects' rights are protected, and promoting a culture of amicable dispute resolution within the EU's data protection regime.